My name is Tim Stevenson. I'm the Executive Director of the Legacy Foundation. With us today is Craig Hirsch. Craig is with the Shepherd Law Firm, is the way that I say it. He is a will, trust, and estate, board-certified will, trust, and estate attorney. Also behind the camera is Michael Hill, his associate, who is also a board-certified will, trust, and estate attorney, as well as a number of their staff who have come to make things flow easily today. The purpose of today really is to give you that annual update on what's going on in estate planning and estate law. We want to give you a little bit of an update as to what's new in the law, as well as we want to focus the lens today on a very popular set of tools that is available for properties, particularly financial kinds of things. We see often ITF, in trust for, we see TOD, transfer on death, we see POD, payable upon death, we see various forms of joint ownership, and so we want to focus the lens a little bit on that today, take a look at the uses and misuses of those tools and how we see that impacting people. This grew out of a series of conversations that Craig and I have had over the last year, in some cases where I've had to call Craig and ask him questions like, who do I disinherit this week? And those obviously concern me. And so out of that grew a conversation where we said, let's bring this conversation that he and I have been having over lunch or in the office to you so that you can kind of listen in on the kinds of conversations we have. Welcome, if you would, Craig Hirsch.
Thanks. Thank you, Tim. Thanks for hosting this today. Can everybody hear me okay? Yes. Okay, great. It's good to see so many familiar faces here. And like Tim said, Tim and I are jointly going to present to you the perils of joint accounts, pay on death, or transfer on death accounts. Many of you may have accounts titled in this fashion, and we're going to talk to you about why you might want to think twice about doing so, and then what the reasonable alternatives to doing so might be. You know, we're going to talk about real life examples. We're not going to use any names, of course, but we're going to talk to you about things that have really occurred in my office. One, for example, happened not just too long ago. A client had assets titled, her brokerage accounts, titled jointly with her daughter. And daughter was in a terrible automobile accident that 2 people were actually killed in. And needless to say, her automobile liability coverage isn't sufficient to cover the damages that will likely be imposed upon her in lawsuits. Guess what the plaintiff's lawyer is going after? He's going after that joint account. So we're going to talk about some of these things. That's just a little primer. Tim, why don't you talk for a moment about why people decide to set up joint accounts?
There are a number of reasons, and the first that we want to talk about is the desire to just help with someone's finances. Paying my bills is becoming much more difficult, and so I'm going to have my daughter come along and begin to pay my bills, and so I think I'll just make her a co-owner of all my accounts, and she'll be able to write out the bills. And I see that fairly frequently. I also see that not only with the daughter, but I see that with nieces and nephews and grandnieces and grandnephews. There are other alternatives. You can make someone a signer on an account without making them either a beneficiary or an owner of the account. And of course, the Legacy Foundation also has a bill pay service where we step in and help with those kinds of services without taking any kind of an ownership or a titling role in the assets.
So, you know, you'll see, by the way, all of you should have, or many of you should have a brochure from me. This is our estate planning brochure we have in our office. inside of it, in case you're having difficulty seeing the projector because of the light, we have these slides we'll be going through. So if you want to follow along, we have the slides. One other housekeeping item, if you don't mind, I know that Tim's office has asked you to fill out an evaluation form. We have one as well that we'd like you to fill out if it's not too much of a problem, because that gives us some feedback as to whether what we're presenting to you is interesting to you and beneficial. And for those of you who fill out your yellow form and turn it into one of my gals in the back at the end, we'll give you a little DVD as our present to you, the 12 most common myths and estate planning mistakes. So, little incentive for you to finish your form. I found if you give a treat, it usually works out well. I have 3 daughters at home, so so that I've learned. Okay, so Tim touched upon help with bill paying, help with investments. Of course, we also, a lot of people say, well, I want to put my accounts jointly with somebody to avoid probate. And we'll talk about where that might work for you and where that probably shouldn't work for you. And then the other thing is a lot of people want to make gifts, but they still want to retain control over the assets. Do you know what the IRS tells us about that? If you make a gift but you retain control, it's still yours for the most part. And we'll talk about some other gift tax problems. Different types of joint accounts. Let me tell you, a lot of people believe that all joint accounts are the same, when in fact, they really aren't. There's 3 different types of joint tenancy, and I'm going to review those with you for a moment right now. The first is called tenants in common. If Tim and I own an account as tenants in common, if one of us dies, does the other one get the account? What do you think? How many people say yes, and it's tenants in common, if one of us dies, the other gets the account? No. How many say no, if one of us dies, the other does not get the account? How many have no earthly idea and are afraid to raise their hand in the presence of a lawyer? The true answer is tenants in common is an undivided interest. So if I die with an account with Tim as tenants in common, my half is subject to probate. My half is subject to probate. Contrast that with joints with rights of survivorship. That's pretty obvious, isn't it? If Tim and I own an account jointly with rights of survivorship and I die, Tim takes the account, doesn't he? Right? That's true. What's this tenancy by the entireties? Can Tim and I own an account as tenancy by the entireties? No. Why not? That's right. We're not married, nor do we ever want to be to each other.
Well said.
Yeah, that would be a little strange. So tenancy by the entireties can only be owned between a husband and a wife. And it is similar to rights of survivorship, except that it's treated as a unity of ownership. The husband and a wife are treated as one unit. Why might that be important? Can anyone guess why that might be important?
Taxes.
Perhaps taxes.
Void probate.
Void probate, that's a good answer. Really, it's for asset protection purposes. If my wife is in the proverbial car accident and hurts somebody and we own everything as tenants by the entireties, they can't get to her side of the assets if it's only her that's liable. If I'm on the car title, though, that's a whole different issue. Tim, why don't you talk to us a little bit about some of the problems with these joint accounts that you've encountered?
I've had a number of opportunities to assist residents of Shell Point in a variety of areas. In some cases, you come to me with questions. In some cases, people come to me and it just doesn't make sense anymore, and I take a more proactive role. And in some cases, I help to settle the estates of people who have died. My first experience with trouble with these kinds of accounts happened when someone died, and I was named as the personal representative of the estate, and in that, it's my responsibility to pay the bills and then make sure that the heirs are taken care of. This is a person who ethically was clean, had strong desire to pay her bills. There were about $15,000 in bills, but 100% of the estate was in transfer on death accounts. And so as the personal representative, I had $0 to pay bills. Add to that, there was not only a transfer on death account, but there was an unfunded revocable living trust, which complicated it even further. And in that particular case, I went to Craig and I said, how do I handle this? And he said, don't. And I had to walk away from that desire to help that person because the people who then inherited what was there not only did not speak to each other, but once they found out it was also TODs, would no longer speak to me. And so what the person meant for good harmed the ability to follow through on the desire to pay bills. It harmed the desire that the family members be in relationship with one another and that the estate be simple. And it complicated it greatly. I came across a situation most recently that got us into this conversation where a person has asked me to help in just the management of the affairs, but everything is in POD and transfer on death accounts, and it's often co-owned with another person. And so if I, on a month-to-month basis, need to draw funds in order to pay the bills, and we do that, the call actually was, Craig, who do I disinherit this month? Because I've got a series of $5,000 and $10,000 and $15,000 accounts, and it would be much better if this person just had a revocable living trust and named these loved ones in to receive. A third situation that I've come across is very straightforward. I have 2 children, and I want each of the children to receive 50%. Would you contact Mr. Hirsch, have him put together a will that says 50%, 50%? And again, that's something I do on a daily basis. And so I said, while we're doing that, let's just kind of take a look at your accounts. Oh, they're okay. Humor me. Let's take a look at your accounts. And 80% of the accounts were co-owned with the daughter, and 20% of the accounts are co-owned with the son. What does that do to a strong desire? Mom's been telling the kids, I'm going to give 50% to you, and I'm going to give 50% to you. And I had to sit down and say, your will has no effect. Because although that's your desire, you have set up the account ownership so that it's distributed 80%, 20%. You can imagine the conversations we had over that one. Fortunately, we were able to get that done during lifetime. We were able to, but it necessitated re-registering all the accounts. There are an equal number of times when it doesn't get caught until I'm called in to settle the estate, or a son or daughter, or a niece or a nephew, or Craig, or somebody shows up at my door and says, Mom wanted me to take care of this, could you help me? And I take a look at it, and we've got a mess. So I've seen that a number of times in the last year.
Yeah, these are real life examples. Tim and I have had these conversations over the telephone. So I'm going to kind of reinforce what he just said. Here's the problems with joint accounts. We're going to talk about TODs in a moment. But remember the client whose daughter was in the terrible car accident. Many of you may have sons or daughters who are upside down in their mortgages today. Does any of you have that going on? Does anyone hear about a deficiency judgment? Do you know what that is? If I owe the bank $300,000, but my house is now only worth $200,000. And I can't pay the bank because I lost my job. So I either declare bankruptcy or I walk away from the home or something like that. Now the bank forecloses the property and they get a judgment for the $300,000 for the mortgage balance. Let's say the bank later sells the home in a foreclosure sale for $200,000. What does the bank have against me? They have a $100,000 deficiency judgment. If I own an asset jointly with rights of survivorship with my parents, can they take that asset? Perhaps. If I own it tenants in common, definitely. So we don't want our children on our accounts, we'll talk about that a little more later, lose the estate tax exemption. How many of you know that we have, a lot of times your attorneys, or if you're my client, we have set up separate trusts for husband and wife, right? Do you know why we do that? Because we use both of your estate tax exemptions. This year, in fact, Tim, wanted me to mention this, some changes from 2008 to 2009, the estate tax exemption increased from $2 million to $3.5 million. So with proper planning, we can shield up to $7 million between a married couple. That's a lot of money, isn't it? But if we have to have separate trusts, and if one dies, everything doesn't go to the survivor, it's just held in trust for the survivor. But what happens if we have those separate trusts set up, but everything was held joints with rights of survivorship between a husband and a wife? We've defeated the estate tax planning our lawyers put in place for us. We may not avoid probate for assets that are held jointly, especially in the tenants in common situation that I described. Current taxable gift. I have an account worth $300,000. Used to be worth $600, now it's worth $300. And I put it in joint name with my daughter Gabrielle. What have I just done? I've made a gift. How much is that gift under the IRS rules? 300 divided by 2, 150,000. How much can I give to Gabby gift tax free this year? It's actually 13. That's right. That's another change from 2008 to 2009. It's 13,000. So I made a gift of 150. I have an exemption of 13. What does that mean for the balance? I have to file a gift tax return, don't I? And what does that do? That reduces my estate exemption. What happens if I have no more estate exemption because I've already made all my taxable gifts? Because the gift tax exemption, by the way, is not $3.5 million, it's 1. It's $1 million. As soon as I start making gifts above $1 million that are taxable, I start making payments to Uncle Sam. So you see how you can very quickly use up your gift tax exemption by making these joint accounts. The other thing that I do, I lose my step up in basis. Do you all know what that means? If I bought Coca-Cola stock at $1 a share, and I held it for many, many years, and I died, and is now $10 a share. Let's say I sold it the day before I died at $10 a share. What happens? That's right, capital gain, $10 minus $1. I have a $9 capital gain that I pay income tax on. That's right. But if I die holding that stock at $10 a share, and Gabby sells it the next day after my death for $10 a share, does she recognize capital gain? No. That's right, she does not. But what happens if we had the account jointly held? Now what happens? How many think she gets no step up in basis? How many think she gets a full step up in basis? How many have no idea and don't want to answer? That's right. Whoever said 50% is right. There you go. You said 50%.
Another case that I've seen that illustrates this is when I have a home up north.
Yep.
And I decide, well, I'll just give that to my son or daughter, and in the end, they will have the basis that I had.
That's right.
rather than the step up in basis, and it can be a taxable situation on down the road.
Or putting the house jointly held is the
Right.
same. It's the same theory.
Right.
So we lose at least part of the step up in basis at death by creating these joint accounts. The other thing we may do that Tim pointed out is that we may circumvent the wishes in our will and trust. If I own everything jointly with Gabby, and I tell Gabby, I say, Gabby, when I die, you share this with Courtney and Madison. Okay? Let's first assume that Gabby's honorable and she wants to share. Okay? So Gabby gets my account, and let's say it's $300,000. She writes a check for $100,000 to Courtney and $100,000 to Madison. What did Gabby just do? She made a taxable gift, didn't she? Do you all see the problems? What if Gabby is less than honorable and doesn't want to share with Courtney and Madison? Can Courtney and Madison sue her and get recovery? Probably not. So you're all starting to see the problems with these joint accounts. Now, my examples, the terrible ones are typically when we have, parent and child, or parent and someone other than spouse. What about spouses? Is it okay for husband and wives to own accounts or assets jointly? And I say, yeah, it's okay, but most of these conditions better apply. We want all of the assets outright to the surviving spouse, which means that we don't have estate tax issues. We're not worried that everything will be included in the surviving spouse's estate when he or she dies. And although today the $3.5 million exemption exempts most of us, what happens if that exemption falls back down to $1 million? It's scheduled to do so in 2011, absent more law. None of us believe that will really happen. But where are they going to get this money for trillion-dollar stimulus packages? Unless you live in Chicago, dead people don't vote. So, my fear is we may have a $3.5 million exemption for some time, but what happens if they start lowering the exemption? So, if we want all the assets to go to the surviving spouse, we're not worried about state tax exemptions. Typically, we have first marriage situations, and all of the children, all the beneficiaries are of that marriage. Because remember, if we have joint with rights of survivorship, and it's his children and her children, and she dies and he takes it, and let's say he gets remarried, or he doesn't like her children anymore for some reason, or someone didn't send him a box of chocolates for his birthday, she gets her kids get disinherited. So we don't have that danger, then I guess it's okay. Where we agree the ultimate distribution of estate, not concerned about remarriage of the surviving spouse, and the right kind of joint tenancy is used. By the way, I can't tell you, Tim, maybe you can speak to this. I have a slide coming up where I say, don't take advice from bank clerks. Okay? I mean, when I was in college, I was working my way through, and one of my jobs was actually as a bank clerk. But you don't need any special legal training to be a bank clerk. They tell you what to do. They tell you how to open the accounts. But do you realize on those forms that you're checking when you open up bank accounts or brokerage accounts, what if they check the tenancy in common box instead of the joint with rights or survivorship? I mean, don't take advice from bank clerks. I was one, but that was before all my years of legal training. So we'll get to that in a moment. Tim, why don't you talk about the parent and child, because you had some experiences with this. Should parents and children own assets jointly? I say no, never.
Uncle Charlie, it's getting much more difficult for you to take care of your affairs. Why don't you just let me put my name on your accounts? Let's go on down to the bank, and then if you need me to come along and pay your bills, I'll take care of that. Great, Uncle Charlie. The same story. It's not just children.
Right.
I can think of almost no circumstances in which I would put a child or somebody's name on the accounts. There are just too many good tools that can be used whereby you can ask for their help and accept their help, but there are legal protections involved in this. It exposes your assets to their creditors. And it does, again, I'm thinking in the terms of a divorce, again, it subjects your assets to their marital issues. It does bring up gift and estate tax issues in the variety that we've talked about so far. Am I making a current gift is a valid question. Am I giving up a step up in basis is a legitimate question. Am I exposing myself in ways that I didn't realize? When I look back over the dozens and dozens of cases I've looked at in the last year, I cannot find one single case in which that is really the registration that I would prefer. The circumventing the wishes in the will or trust goes back to the whole thing of titling property. Your title to your property and the beneficiary arrangement to your accounts supersedes your will or trust in most cases. And so we want to be very, I don't know where that sound was coming from. So we want to be very careful that we don't inadvertently supersede what we wanted to have through our will or trust by doing that. And then I've got a situation where there is a desire to move it back into the individual's name, but we've got co-ownership with a brother, a sister, a son, a daughter, a niece, and nephew in Michigan or New Jersey or California, and the bank wants their signature in order to affect that change. And if they don't want to sign or be cooperative, you're not going to change it. You're not going to change it back.
That's right. You know, that last point is very, very pertinent. Even if you want to undo a transaction, if your joint co-owner doesn't want to sign, you might not be able to undo it. Now let's talk about pay on death or transfer on death accounts. We're moving away from joint accounts, and now we're talking to pay on death accounts. And typically these are a little different. Pay on death accounts, I own the whole account during my lifetime, and then it's transferred to my beneficiary, named in the bank papers at my death. And that's important, named in the bank papers, not named in your will or trust. So, like Tim said, if you have various accounts naming various beneficiaries, we get back into the problem of which beneficiary do we disinherit when we're paying your bills under a power of attorney. Now, one of the reasons people do this is because they want to avoid the probate process. The bankers will tell them this is an easy and cheap way. You don't have to pay a lawyer. You don't have to worry about these things. Just do a pay on death account. That's fine, folks, if you have 50 grand and that's all you have and you put everything in pay on death to 2 of your kids. It's not fine when you have a significant estate, more than a few $100,000 or more. Those, you're cutting your nose off to spite your face because of all these problems we're talking about. So what are some of these problems? Again, we're circumventing the wishes in the will and trust with a pay on death account. We could be fouling up our estate and gift tax planning if we already have wills and trusts that have that included. Like Tim said, unintentionally disinheriting a beneficiary, and then no liquid funds to pay for final expense. Why don't you talk about the funeral bill, was it the cremation bill with that one file? Do you remember what I was talking?
Yeah, if anybody has a benevolent heart, I have someone that, again, left everything through PODs. The children had no desire to pay grandparents' funeral expenses. And so I'm still sitting 1 year later with a debt to a local funeral home for a woman that I know wanted her funeral to be paid for. And the grandchildren who inherited her estate through a TOD account decided they didn't care to pay for grandma's funeral. And do I get emotional about this stuff? You bet, because I've watched as I've been able to talk with individuals and I know their desires, but at the same time, the grandchildren didn't understand it. Another thing that you and I have talked about is on that third line, and that is I think this is going away, I think the battery's about dead. The TOD accounts, the TOD accounts do not take into consideration if the person named predeceases the person who owns the account. And that's close to me. My father predeceased his parents. So if you're in my office, I will always ask you, what's your desire if your child were to predecease you? And the POD does not take into account if that individual were to predecease you. So again, when it comes to settling that affair, what was meant for good becomes more of a problem than if we'd have just handled it through the estate documents to begin with.
Do you remember when Tim said that he had called me about that certain account and said, what do I do? And my advice was what?
No.
Don't do anything.
Design.
You know why? Can anyone guess why? With the TOD accounts, Tim has no money to pay for funeral expenses, no money to pay for accountants for final tax returns, no money to pay for lawyers to do what they need to do to clear up the estate. But if he steps in and starts doing those things, does he not subject himself to the liability for all those things?
I don't want to pay your taxes out of my pocket that your grandchildren are supposed to pay.
Right.
I'm selfish that way.
That's terrible of you, Tim.
Yeah.
I don't know why you wouldn't want to do
I would rather
those
take
things.
the money and go fly to see my grandson.
Right. When you set everything up in a TOD account, you run that gamut. You run that risk. And it's not just theoretical. It has really, really happened in files that we're familiar with. So what are the better solutions? Now we've told you all why not to do, what not to do. Has everybody bought into what we're saying? Does everybody agree? Let's hope. The better solutions are durable powers of attorney and revocable living trusts. When you name somebody as your attorney in fact, as under a that's what the person who has your power under power of attorney is called, an attorney in fact. When you name someone under that document, they have powers to act for you. With revocable living trusts, they're even better. And we'll talk about some of these differences. Let's talk first about the durable power of attorney. In a durable power of attorney, you name someone to take care of your financial affairs for you. And you can either give them very, very broad powers, including the power to sign deeds, the power to move investment accounts, the power even to create, let's say, a family limited partnership. You can give them very, very broad powers, power to sell your business, or you can limit the scope of their authority. You could say, I only want you to do bill paying for me, so I'm just going to give you a limited power of attorney for that express subject. There's no gift tax consequences on a power of attorney because the person is not receiving anything from you. They're acting in your stead. Now, the durable means it survives your incapacity. It does not survive your death, by the way. At your death, the durable power of attorney ceases. The durable power of attorney does not circumvent your wishes in your will or your trust. And finally, it should be current. And that's one of the problems we see with powers. Tim, why don't you talk a little bit, I don't know if you've encountered some of these with local banking institutions. Let's talk about powers of attorney and limitations on them.
I will tend, if you come to talk with me, to tell you, I have little ways that I say it, and I find myself repeating it. When it comes to durable powers of attorney, I think healthcare surrogate living will would also be in that league. The newer the better. And my experience has been when I go to an institution to try and use a durable power of attorney, the more current, the more reflective of current law, the closer your signature is, the more willing they are to cooperate with us. There are some institutions that are a pain to deal with, and I have to go to great lengths. We've got a situation right now where we have identified some assets that the person had forgotten they had, and I'm interacting with the bank about it, and it's going to take several weeks for me to prove that I am who I am and that I have the authority, and that's okay. But what I'm finding is the fresher, the better when it comes to that, and they do look at the detail. So again, a durable power of attorney is probably not a do-it-yourself thing that you download a form off the internet. It's probably something that merits a conversation with a local attorney so that you make sure that the right powers are included in the drafting of the document. I think that's probably what's most helpful.
What I was going to add to that is, now, I'm using Tim as an example in this talk, but many of you may have a son or a daughter or a nephew or a niece or somebody like that who's named as your power of attorney. It's hard enough for Tim to do it when you're naming Tim, but just imagine this when you have a nephew, niece, son, or daughter. You're here in Fort Myers, and let's say your account is at this local Bank of America, right? And your son is in, let's say, where I grew up, Indianapolis, Indiana. And you're incapacitated. Now he has to do these things for you. So he calls the bank and he says, now I got it, how do I write these checks? Well, what year was the power of attorney created? By the way, if it was before 1996 in Florida, it's not valid. What state was it created in? Is it on our form? They do that all the time. The statute, by the way, they're not really supposed to do that. Is it on our form? On and on and on. Meanwhile, bills are going unpaid. Or maybe your broker has suggested that you make certain trades and no one seems to have the authority to do so. That's the problem with powers. Now, we still do powers. I do them for all my clients as part of the package. And they are useful. And I'm not saying that they're garbage. They're useful. But you have to stay on top of these things, and the state laws change a lot with them. So you want to make sure that you're up to date with them. And again, they do cease at your death. Now let's contrast that with revocable trusts. What happens with the revocable trust? When I own a revocable trust, what am I supposed to do with my brokerage account? I'm supposed to put it in my trust name. If I have a Schedule A on the back of my revocable trust and I list my Raymond James brokerage account, because that's Paul. Paul will be here next month. If I've named my Raymond James brokerage account on Schedule A, have I transferred it to my trust? No, I have not. How do I transfer it to my trust? I actually have to go down and get my broker to help me with this, or in our case, when we're doing your updated documents, that's part of our funding process. We actually have, our funding gals aren't here today, are they? I have my drafting gals. I got Dorothy and Maria, but then Katina back there. But we have people in my office, that's all they do. They work with your financial advisors and your banks to make sure everything is properly titled. So, for example, in my case, it would be Craig Hirsch as trustee, or in my case, both Patty and I. My wife and I are both trustees. Craig Hirsch and Patty Hirsch, co-trustees for the Craig Hirsch Revocable Living Trust, dated whatever day I signed it. That's how the account should be titled, so that my trust owns it. So let's say I become incapacitated and Patty is my successor trustee fully and individually. Does she have to do anything to transact business on my account? Does she have to present? No, it's already taken care of. It's already taken care of. What happens if both Patty and I are God forbid, we're in a car accident and our next trustee steps in? Do they have to present any new documents to the trust company or to the bank or to the brokerage firms? No, they don't, because everything's already held in the trust. They just have to read the trust to see who has the power. If we die, do they have to do anything? Like the power of attorney ceases. Does my trust cease at my death? No, it continues on for my lifetime. The trust is there to pay for my accountant to do my final tax returns. The trust is there to pay for my funeral expenses. The trust is there to pay for any legal fees that might be necessary. My children or grandchildren can't run off and say, I'm not going to do that stuff. So
let me ask you a non-lawyer question, because I'm not a lawyer. I think everybody, if you don't know that, you should. I'm not a lawyer. It's not that I don't like lawyers. But let me ask you a non-lawyer question. It seems to me I serve as power of attorney and I serve as trustee. It seems to me that I am held to a little higher standard with a trust. The trust law seems to be so thoroughly written that if I step in as trustee, not only do I know what to do, not only is the code very clear, but I'm also held to the standard of a trustee versus that of someone operating simply off a power of attorney. Is my impression of that correct?
Yes. In fact, you gave me an opening to talk about this too. In 2007, the Florida Trust Code changed entirely. Those of you who are our clients have been invited to other workshops that we presented about updating your trust, and we're asking you to update the trust to the new trust code. The new trust code is actually very, very good. It's very good, and it's improved every 10 years or so. This is actually out of something called the Restatement of Trust Third. You don't want to hear this. The academics do all this, and then all the states fight over what provisions they want in their bill. But the new Florida Trust Code came out in 2007. We are asking all of our clients who have not updated since then to go ahead and update. But it does provide some very, very good guidelines about what the trustee can and can't do, how the trustee must notify other beneficiaries of what's in the trust and the accountings and so forth. This is after your passing. During your lifetime, you're in complete control. You can change everything. You're in charge. The new Florida Trust Code, although does impose significant liabilities on people who do things incorrectly following your death. So there's a lot more protections in the new Florida Trust Code on trusts as opposed to just trying to operate under power of attorney.
Okay, that was my impression. I thought that was true.
So let me talk for just a quick moment about the difference between a will and a trust. Does everybody know what a difference is between a will and a trust? What's a will? We all know what a will is, right? If I die, I have a will, and it says who gets what at my death, right? Yes. Now, if I own everything jointly with my wife, is anything subject to probate? No. What is probate, by the way? Is it a tax? That's right. It's a court procedure. It's not a tax. Probate is where we file your will with the clerk. The judge admits it as your last will. Why might that be important? What if you had a will from 10 years ago and you updated it 5 years ago and you updated it again 2 years ago? So if someone actually filed a will that was 10 years old that wasn't the right one, the judge gets to admit the most recent one. And if there's any controversy, the judge decides which one is the most recent one. So there's a probate is the process. Your will is admitted to court. Your personal representative, that's what we call the executor here in Florida, is appointed. Letters of administration are issued. Creditors are cleared. Taxes are paid. And beneficiaries are given accountings and discharge. It is a public process. Can you go down the courthouse today and read anyone's will who's filed? Yes, you may. Can you see their inventory? Yes. Maybe. If you're an interested party. But it's not hard to claim that you're an interested party. I file a bogus creditor claim and all of a sudden I'm an interested party, at least for purposes of reviewing the inventory. So the probate process is a public process. That's why we here, and by the way, in Florida, must you have an attorney to represent you in probate, or can you do it yourself? You must have an attorney. In some states, like New Jersey and New York, I understand, you don't need an attorney. So those attorneys up there aren't so worried about doing wills as opposed to trusts. They'll tell you, oh, don't worry about it. But in Florida, to open up a probate administration, a full probate administration, you need to be represented by counsel. What is the statutory reasonable attorney's fees for a full probate? 3% of the first million, 2.5% on the next 2 million, 2% above that, and then it's a graduated scale. So if I have an estate worth $1 million, what's a reasonable attorney's fee? $30,000. Now there is some work in trust still. There's some trust administration fees. But trusts are preferred to wills because when we have a trust, what does our will become? It becomes something called a pour-over will. You all heard about a pour-over will? It's like a safety net. Just catches anything that you might have in your name individually, puts it into your trust. So you may still have a will, but hopefully we don't have much, if anything, subject to the probate process. Everything is in the trust. Trust means private process. So Tim, what happens with a trust if we have a bad trustee, a child who's not totally honest with things?
Well, you're going to have to end up answering that. The fact is the trust code is going to hold them to a standard of care.
Right.
And if they violate that, then they are liable for up to 40 years, you
Yeah,
told me?
yeah.
They're liable for penalties for a long time.
Mm-hmm.
So it's a pretty rigorous process to make sure that you're clean.
The trustee is personally responsible to creditors, trustee is personally responsible to beneficiaries. But because it is a private process and there is no court supervision, you better make sure that you're naming, whoever you're naming, is going to be a very honest and responsible party. They're going to work well with the lawyers and accountants and investment advisors. I get this every now and then. I'll ask my client, who do you want to be as trustee? My eldest son, Jim, has to be trustee. Why? Jim's the eldest, okay? And what happens if you don't name Jim? Well, he'll be upset, okay? Tell me about Jim. He's been divorced 3 times. He's been in bankruptcy. Oh, he just got foreclosed out of his house. And is that the party you want as your trustee? No. Don't just do it because it's the oldest child. We'll take questions afterwards if we can. So even though trusts, I think, are preferred, there are some dangers I'm pointing out, so make sure that you think through those. Let's see, where are we?
While you are changing that, one of the things that helped me to understand probate, and correct me if I'm wrong, I think probate, the word goes back to the Latin to mean to prove.
That's right.
And you're proving a set of things. You're proving this was my last will. You're proving this was my intention. You're proving the process worked as I had laid it out. And the process mimics that in such a way that by the time the judge in Lee County says, Tim, you're done, I have proven that I have done everything that was laid out for me to do. And that took some of the threat out of it as being an all evil. There is a proving process there that I think it has some value.
So what have we learned today? I had a zoology professor once, and he's actually a professor. This is my high school, Dr. Russell. And Dr. Russell used to tell us, if I ever see you out in the outside world after my class, I want you to remember just this from my class, that the order is kingdom, phylum, order, class, genus, species. Right? I saw Dr. Russell in the mall about 20 years ago, and I'd already been graduated several years by that point. And I said, Dr. Russell, kingdom, phylum, class, order, family, genus, species. He hugged me. He hugged me. That's all I remember from zoology. But I want you to remember this from today, because we gave you a lot of information. Don't take advice from bank clerks, please. Sometimes even from your brokers. Yes. Your brokers will tell you things about this stuff that's not entirely accurate either. Get your lawyer involved. You know, when my clients meet with us, I'll say, do you want your broker in here with us? Do you want him on the phone? I invite them into the process. And they should with your lawyer. So don't take advice from bank clerks. Keep your plan up to date. Can't say that enough. Keep your plan up to date. Things go stale. Laws change. Now, in response to that, for those of you who care to take a look through this, do we have the maintenance brochure in here? No. Oh, we don't? Okay. We describe our maintenance program in our brochure. We keep our clients' plans up to date once they have their 2007 foundational documents or later. And then finally, make sure your attorneys and financial advisors are on the same page. Make sure they're communicating with one another about these things. Like in Tim's example, where Tim said, 50-50 on the will, but this account was owned 20%, the other account was owned 80%.
Right.
That's a prime example of the lawyer not knowing what happened with the bank officer or the investment advisor, or the investment advisor not caring what the lawyer did. So that's that's all I want you to remember from today. Pretty easy, right? All right, so do you have anything to add?
I like that. Don't take advice from bank clerks.
I mean, they're nice people, don't get me wrong. I mean, I was a bank clerk myself. They mean no harm. But they're not trained in this. This for folks who have substantial estates. This is pretty heady stuff. So let's open it up for questions.
Okay, first question was right here.
Yes, sir.
With the different types of joint accounts,
I'll repeat the questions. Don't worry.
with the different types of joint accounts, if you're transferring real estate, who has to sign the deed?
Okay, the question is, with different types of trust account, or joint accounts, tenancy in common, joint with rights of survivorship, tenancy by entireties, who has to sign the deed? If it's tenancy in common, I can deed away my 1/2 interest without the joint owner.
One person signs it.
Yeah, but I can only deed away my half. I can't deed away the whole. Or if I have an undivided 30% interest, I can deed away my 30% interest. With the other ones, tenancy by the entireties or joint with rights of survivorship, typically you need all of the joint owners to sign on that transaction.
How difficult is it to change the custodian in the living trust?
How difficult is it to change a custodian? You're talking about the trustee of the living trust? Very easy. You just need to amend the trust. Now, this is for revocable trusts as opposed to an irrevocable trust.
Right.
Irrevocable trusts are typically like life insurance trusts. You're trying to remove something from your estate. Those might be more difficult to change. We have to read the trust instrument. Typically in revocable trusts, very, very easy to change your trustee. Yes?
Did I understand you correctly to say that durable powers of attorney made prior to 1996 were no longer valid?
That's right. In Florida, the Florida law was changed October 1, 1996, Mike? Mike, he knows. You know, that's a benefit of having younger partners who are on top of the law. On October 1st, 1996, Florida law was changed, which created a whole new power of attorney statute. And the net effect of it is that no one has to honor a durable power of attorney that was created before that date. Yes, in the back.
FDIC coverage is only for $100,000, and there seems to be complications today. If you have a revocable, one person has a revocable trust, and they have, say, $200,000 at the bank, but they only have one beneficiary.
Right.
Then the FDIC is not covering the other $100,000.
That's a good question.
If you do not want to, say you want to stay with that bank because it's a safe bank, you know, how do you cover?
Okay. Is there such a thing as a safe bank today? Her question was, for those of you who couldn't hear, is a question, first, that's several parts. Let me break it down. The first question is, really, is my revocable, is an account that's with a bank FDIC insured if it's in my trust? The answer is yes. How much is it insured by? By the way, on our website, you'll see the website at the bottom of the slides, and it's all over our brochures and stuff. I have something called an estate planning blog. It's a family legacy blog. We address this issue in one of the blogs. So if you have access to the internet, and you'll see it talks about the FDIC insurance, it's a much more extensive write-up about it than I can answer in just a couple minutes here. My law partner, Jay Brett, who sits on the board of Florida Gulf Bank, which incidentally is a very strong bank, I'll put the plug in for them today, wrote that blog. But in answer to your questions, if I have a revocable trust with more than one beneficiary, I may in fact have more than $100,000 of FDIC coverage. I may have $200,000 or $300,000 depending on my beneficiaries. Read the blog about that. But if you only have one beneficiary, I don't have a good answer for you. You know, if you're only limited, if you're only covered up to 100, then you might want to spread it around a little bit. Over here, yes.
Yes, I have two questions. Actually, a comment too. FDIC insurance has been increased to $250,000.
For this year.
Yes, this year, but it could be extended again.
Right.
Okay. Question one, your estate has to be over a certain amount before it goes into probate in Florida, as I understand it, or in other states. In other words, let's say theoretically I have an estate which is only worth $30,000 or $40,000. After the transfer on death, payment on death, exclusions are taken out. is it gonna go into the probate process in Florida?
If I have, okay, the question is, how much can I have in my name individually before I have a full probate? Is that the question?
Yeah.
The answer is $75,000 of assets in my name individually. Anything above that, and I have a full probate.
Can I jump in and give you one exception that you and I are working on right now?
Right.
We have someone who has a small estate, but the creditors are not willing to sign off and just let us write them a check. And the creditors have driven us
To a full
to
probate.
a full probate. So there's a situation where it's not the problem that the individual, it's the creditors won't sign off, and we have to go through the probate process.
Yeah, in order to have a summary administration, which Tim is describing, it's a very easy probate process. We can either have no creditors, or all the creditors have to sign on the petition. So, and when we have difficulties with that, back in the back.
Sorry, I have one more question.
Well, can I spread it around just a little bit? You know, we'll stay afterwards. So I'm just trying to get a bunch of questions, and then we'll go another couple minutes, and then
Yeah.
we'll be happy to entertain questions later. In the back, sir.
If you said $75,000, but I think you also say that if it's a contractual event, like an annuity,
An annuity, yeah.
what about those things?
Okay, that's a good question.
Or any of the other stuff?
Annuities, life insurance policies, and IRAs and assets like that that name beneficiaries outside of our names individually, those are not subject to probate. That's right. Yes, sir.
About a year ago, there was an article in the paper where certain lawyers in the state of Florida were attempting to get the law changed so that almost everything had to go through probate in order for the credit card companies to be able to get at the money that people need.
Yeah.
Has there any action been taken on that?
Okay, the question is, there was an article in the paper that allegedly said that there's a bunch of lawyers working for banks trying to get everybody to send everything through probate. I sit on various Florida State Bar committees. I have not seen any such bill, so I'm not familiar with what you're talking about. I will tell you that the trust laws, though, were tightened up. This last set of bills, this new trust code, was tightened up to impose more stringent liabilities on trustees who don't clear the decedent's creditors. So that might have been in response to that. But no, you need not worry about probate. Let's take a couple more, then we'll stay later. Yes, ma'am.
At the time of settlement, is it mandatory for the lawyer in the state of Florida to send each heir a copy of the entire will?
Okay, the question is, in a state settlement, is it mandatory for the lawyer to send each beneficiary a copy of the will? Let me answer that in two parts. Aren't lawyers great? Isn't everything it depends? You know, that's what we learn in law school. They warp our minds. The short answer to your question is yes. Every beneficiary is entitled to a copy of the will.
But is it necessary at the time to send one, whether they request it or not?
Yes. So, yeah, every beneficiary is entitled, and they should be sent a copy of the will. Now, with that said, the new trust code comes to our rescue if we have a beneficiary that we don't want to know anything about our trust. We want them to be a beneficiary, but we don't want them to know much about it. There's something called a designated representative in the law. And this is, by the way, since 2007. This is brand new. Let's say daughter Susie is really a spendthrift, and we fear that if we leave her too much money, Nordstrom's will end up with most of it. Okay? So, but we do want to provide her an income stream. So what we can do is we can designate a representative to receive accountings and notices on her behalf and keep her in the dark. So if you have that situation, you actually can utilize that under the law. One more question, yes?
Doesn't the step-up basis disappear at the end of 2010?
Hey, that's a great, boy, this is a smart group. That's why I love working with so many of you, or so many of you, they're my clients. I love working with you all because you guys are on top of this stuff. The question was, do we lose a step up in basis in the year 2010? Because, you know, what the current, let me back up, what the current estate tax exemption provides, last year, remember, it was $2 million a person, right? This year, it's 3.5. And if I'm on life support and I'm worth $15 million, my kids don't unhook it till January 1 of 2010, right? Because in 2010, I can die with an unlimited amount of assets and it's not subject to estate tax. But this is what your question is speaking to. What do? Those sneaky legislatures, what in the world did they do? They more or less traded the estate tax system for a capital gains system, which means that you don't get the step up in basis and the capital gains are recognized and paid instead of the estate tax. Now, the capital gains is a lot lower today, so it's a good trade-off. But did you realize that that's the system we had before 1977? And by the way, any of you Canadians? Any Canadians here? No. Canada does that. There is no estate tax in Canada. Even if you try to transfer something to a revocable trust, you recognize the capital gain on the transfer, the difference between its current value and your basis. But why did we in America go away from that system in 1977? The reason is because no one knew what the basis was of their parents' assets. We can readily determine the fair market value of them today at the time of passing, but we can't, a lot of times we have no idea, and in fact a lot of people don't even know what their own basis is in some of these assets. So that's the mess that we get into in 2010 if they don't change the law. But it's only for 1 year. So if I'm on life support in December 31st, 2010, do they not unplug it till January 1 of 2011? I don't know. But absent any further law, we're back to $1 million.
That said, the next 2 years are going to be a real changing environment, and we will try to make sure that we give you updates as we go through this. I believe that we're going to see some kind of a change, but
we're going to
who
see
in the
changes
world
probably
knows?
this summer, yeah.
Yeah, so we'll keep you abreast of the changes. Again, I appreciate your involvement with these sessions. We'll hang around here, but I know some have already told me that you need to leave on a timely basis, so we'll break now.